Welcome to Public Forum, a community outreach program produced by North Idaho College located on Lake Coeur d'Alene. Featuring guests from around the globe addressing a wide variety of subjects, Public Forum serves to educate and enlighten. Please join host and moderator, political scientist Tony Stewart, in welcoming today's guests.
I am most pleased to welcome you back to our series that we're dealing with on law in this country, and today's program is going to be titled American Law and Ethics. Our guest is back from 2 previous weeks. I'm so pleased to welcome back to the program Glenn Walker. He is an attorney in the state of Idaho, and he comes to us with great credentials. First of all, our guest was prosecuting attorney of Kootenai County, Idaho, for over a decade, and he was, I think, as effective a prosecuting attorney as we have had in our state. While serving as prosecuting attorney, he worked very, very hard on legislation in several fields, including combating hate crimes. In fact, he got the first conviction in Idaho under the anti-malicious harassment law. He is in private practice, and he specializes in both criminal and civil law and has a very, very successful firm. Glenn, welcome back. It's such a great pleasure to have you here with your expertise, and you're gracious to take so much time. You're very busy in your practice, but we really think our viewers will get a lot out of dealing with the ethical questions that relates to the practice of law in America.
Happy to be here.
I'm going to start off with some, definitions and let you share with us. We hear about ethics a lot. We have courses in the academic world on ethics, and in all professions, medicine, law, and all, there are codes. And in your particular profession, the Code of Professional Responsibility. Give us your concept and idea of, in the practice of law, what the term ethics means to you.
Well, you know, the thing is, there's the ethics of the individual lawyer, but in every case there's going to be at least 2 lawyers. So each one has their individual ethics. They have responsibilities to the Bar Association in general to try to upgrade and uphold the integrity of the Bar Association. We have the responsibility to the courts as officers of the court. We have responsibility to the public at large as a public citizen. And most importantly, we have the responsibility to the client as advisor to the client, as representative of the client, advocate for the client, and evaluator of his case, and so forth. So the lawyer is torn in many different directions. In most cases, Tony, all the different responsibilities of the attorney are harmonious. But every now and then, there's a conflict between one or the other of these. It's a really a very, very difficult question to ask or answer. It's just that we have so many responsibilities in so many different directions. But first and foremost, we have to be true to ourselves and to our client. We have to represent him zealously or her zealously, but at the same time, we have a responsibility of fair dealing with the opposing side and with the public. And we have a responsibility of being candid with the court.
You know, it's like many other things in life, but there are complexities, and at times, in particular situations, it calls upon one to really analyze all those different responsibilities. You're oftentimes answering to a lot of different sources. One book that was written by Saul Linswitz with Martin Mayer quoted in the different chapters people who have addressed some of the questions that you're talking about. And one person quoted was a Roy Grutman when he said, accepting a client is even a moral decision. That to me was an intriguing statement. You know, there are cases you take, there are cases you don't take and all. Could you share with us what he may be referring to, or at least from your perspective of, that's not always an easy decision itself, is it?
No, and I don't know, of course, that particular author or that book, but I can tell you that I face that every single day of my life, and I do face that with all the clients. I've been blessed that I have a substantial clientele, and I don't have to take cases I don't want to. So I can tell you one area where that really applies, and that for me as an individual, and that is in family law areas. I do an awful lot of custody cases, and I choose not to just be an advocate. As I indicated previously, that's one of the primary functions of a lawyer, is to be an advocate for the client. But nobody really represents the children. the attorneys are hired by the parents to represent the parents. And I personally take it and extend it, even though I represent the parent, I treat it personally as if on a moral basis, as if I'm representing the client. So for me, in those kind of cases, it's always a moral decision. And of course, you can go beyond that to even simple contract matters, real estate matters, certainly in criminal areas. You have to be able to, in your own conscience, do a good job for the client. If you cannot feel good about that person, if you cannot feel that you have a just cause, it's very difficult to be an effective advocate. So I think that morality is always there, but that does not mean to say that a person would be immoral because he doesn't believe in a client's cause. There are plenty of times you represent unpopular causes, but nonetheless you have taken on this responsibility, and you have to do it justly.
I was talking with an attorney the other day, and I have great admiration for attorneys, and you're certainly on that list because I think they really defend the Constitution in a way. Without them, I don't know what we would do. So I have a lot of conversations, and I was talking to this attorney, and he'd turned down a client. He met the potential client in his office, and they discussed a number of things, and he didn't reveal anything to me that he should not, didn't mention a name or anything like that. All he said to me was that he declined the case because as he talked with the individual and saw his personality and philosophies, he found that he had no rapport with him. He found it uncomfortable, that he didn't think that he could be his best representative for the case. So is that another one of those moral decisions where
well, it is.
It's a commendable thing to do, to say, no, I'm not the right attorney for you?
Well, the attorney you're speaking of did the right thing. If he felt uncomfortable, if he felt like he didn't have the rapport, he did the right thing in declining the case. And I find as I get older in the practice of the law, I find that I'm able to do that. I'm able to recognize that case more readily than I was in earlier years. But the reality is you're going to have disputes with clients from time to time. And you have to have a rapport with the client. I've always said that the attorney has got to run the case. It can't be driven too much by the client, because the client has the most unobjective seat in the theater. And if the client has enough objectivity to run the case himself, he probably could represent himself, which of course he can't do because he can't get objective enough. So the sooner you can recognize, if you can, that you don't have that rapport and easiness, identification with the client, then you really ought to get off.
I have some other things that I want to deal with, of course, but that leads to another question. Your comments always build a bridge for another question for me. And you're in the middle of a case, and we're dealing with ethics, and you're doing your very best to represent that client. And some clients are, I'm sure, very much a pleasure to represent. Others are challenging. When you've reached a critical moment, even prior to a trial, and a client is insisting on going down the road that you as a professional know that is really a disaster, how do you get that client back on track? Or can it reach a point to where that really, even though you've taken the case, that it's going to be one in which you really can't continue to proceed? I mean, is it okay to change prior to trial? Because, the difficulty just becomes too great and unfair for both parties.
It's really the most awkward area, the most difficult area, the most heart-wrenching area of all is when you're getting near the trial and you find you cannot identify with the client. The judges control the attorneys in terms of being on or off the case. You can't just get off of a case. You have to petition the court to release you from the case because you're an officer of the court, and the court has to control its calendar. The cases have to keep going forward.
Is that civil as well as criminal?
Civil and criminal. The courts control who gets on and who gets off. If you can get another attorney to take your place, then it's an easy process. You just fill out a form called substitution of counsel, and another person takes over. That new person may have to ask for a continuance of the trial. So a judge will oftentimes say, I don't object to the substitution of counsel, but the case is going to go forward. In most cases, in civil cases, the judge would allow the new attorney to come on and the case to be postponed if necessary, but not always. So sometimes the calendar of the court will dictate that a person not stay on the case. Having said that, if a person doesn't want you on the case, you can't stay on it. So it becomes one of those catch-22s at times.
And also in relation to this, I'm quoting again from this same book that was, I thought, quite intriguing, dealing with lawyering at the end of the 20th century. Another one of the contributors to the book, Paul Fruin, once said that the legal profession must strive for and will be measured by three standards: its independence, its availability, and its learning. And I'm sure that means the whole court system as well as attorneys. How would you react to, I hear him saying here that, to get justice, you have to make sure there's some autonomy too, that the courts are separated from the other two branches of government in actually the hearing the evidence in a particular case.
Well, in every nation, the independence, the first of those three that are mentioned, is crucial. And we've always looked at, well, suppose in the days of the Soviet Union, suppose a person, either a Soviet citizen or a foreigner in the Soviet Union, is charged with some sort of a crime. What kind of counsel would that person get? And I know I never had confidence that the Soviet citizens or East European citizens had that independence from their attorneys. But in the United States or in Great Britain, we've never worried about that because it's just part of our culture, the independence of our attorneys. So that's fundamental to it. The second part, the availability part of it. Counsel has to be available to poor people as well as wealthy people, and oftentimes poor people and even not so poor people really cannot afford. That's so crucial to our system. It isn't always there. And while I'm a real strong supporter of our system, I also am not going to say that everybody is always treated the same and everybody's always treated fairly. It isn't. We hope to have a level playing field. We try to get that in our court system, but unfortunately it's a system made up of humans and it's not always going to be that way. And I don't remember
and the
last
third part,
one.
It's learning.
It was learning. I was going to say competence. Yes. Well, obviously, you've got two. Assuming you've got one lawyer on each side, are they going to have the same degree of learning, same degree of competence? If they do, then you've got it tailor-made for justice, and you hope then you've got a fair fact finder, whether the judge or the jury, and that's going to work. But the system is fraught with errors because we're all human. I would add a few more things to it, but those three are a good start.
I'm going to let you do that in a moment, but like the availability, accessibility, I guess there is absolutely no way, and this is not a criticism, there's no way of a judge sitting there and saying, here are the two attorneys, and one's just out of law school, another's been practicing 20 years. There's no way of guaranteeing that those lawyers have the same amount of savvy and ability in the courtroom. But what is important, I think, for the 1960s, and get you to react to that, one of the great strides forward was when the U.S. Supreme Court said that when people are accused of crimes, no matter how poor or lack of education, they will be represented by counsel. So did the court not make a great stride forward saying at least we can make sure that you're not going to be tried as they had been in the past without counsel? Well,
yes, that was certainly necessary, but the Sixth Amendment to the U.S. Constitution speaks of assistance of counsel, and it's effective assistance of counsel is what we're referring to. So there have been many cases throughout our history that have been thrown out by the Supreme Court because of ineffective assistance of counsel. And this, of course, is in criminal cases. There isn't anything in our civil system to allow a case to be overturned because the attorney was not competent. But of course, we know that does happen. That cases are messed up. That justice is not done in civil cases as well as criminal cases because there is not a level playing field among the attorneys.
But certainly your point is so well taken that we've seen, and fortunately this is in a very small percentage of the cases, but there are cases where, in criminal matters, where attorney maybe was appointed to the case or whatever the reasons were, that they really didn't do their homework and they really didn't ask the right questions, and so higher courts have overturned some of those convictions. So that is a safety net there are grounds for appeal?
Well, it is, but I can tell you that the ineffective assistance of counsel is a grounds for appeal that's commonly brought, but it isn't, as you indicated, it isn't usually going to work. It's the very small minority of cases. Usually the appellate court will say that the decision the attorney made was a judgment call by the attorney, that they're not going to go back in time and substitute their judgment for the judgment of the person there. But every now and then, the facts of the case will be so gross that the appellate court will overturn it because the counsel simply wasn't sufficiently competent.
In the same book, excuse me, I'm going to go to a different book. There's a book called The Moral Compass of the American Lawyer, Truth, Justice, and Power, by a Richard Zittrain and Carol Langford. And Robert F. Kennedy, who was an attorney and the Attorney General of the United States, had an intriguing quote in here, and I will get your reaction to that. He once said, "Courage is the most important attribute of a lawyer. It is never dated or outworn, and it should pervade the heart, the halls of justice, and the chambers of the mind." We certainly have, in a quote, we certainly have examples of courageous attorneys everywhere, and locally here, and I certainly would put you in that category. You've always, in my watching you, and I'm thinking of Norm Gessel and Morris Dees and Ken Howard and a number of attorneys, you never took a opinion poll before you took a step forward to do something you thought was very important to the court system and the Constitution. And where does that come from, and how do you explain this quote by Robert Kennedy?
Well, first of all, I certainly agree with him. Courage is going to set a lawyer out head and shoulders above the crowd. Every lawyer is not going to have it, nor is every person across the board, doctors or teachers or minors, are going to have that, and it's going to set people out. If you have that one element of courage and add to that passion, then you've got a big step on the crowd, and you're going to prevail in most cases. All I can tell you is that it's just fundamental to leadership in society in any category. And the person with courage is going to stand out. The law is a jealous mistress, as they say. It requires so much of you, and if you are able to put courage with it and passion with it, you're just going to have that intangible quality that's going to give you a presence that others are not going to have. It's going to make the zeal that you're supposed to operate with appear to be part of you. It's going to make you appear sincere and genuine, and it's going to stand you out in the crowd.
I think your point is well taken, whether you're talking about attorneys or other professions or political leaders. We see it, certainly we observe it more closely in political leaders because we see statements from them almost daily, and that is, some people just have that courage to do that. They can, and also they are visionary to say, this is the thing I have to do, it's the right thing to do, and then not only do they stand out, but history is kind to them also in that process. I want to go back to, and I went down here for purpose to get these in before on this show, but when we talked about the three standards that was in this particular book on independence and availability or accessibility and learning, you had indicated in answering that there are other factors or standards, and would you share some of those from your years of practice, both as private practice and also as a prosecutor?
Well, Tony, really I was going to talk about courage and passion was what I had in mind at that moment. But what has always been something that I look to, and I just have always said when I was trying to hire deputy prosecutors or whenever I was it's oftentimes just picking key friends. I look for two things. I look for a feel for people, and by that I mean someone who understands the human condition. There are certain moral absolutes that you can identify with. That's true, but for the most part, we're all people, and we're subject to human frailties. So if I've got someone who can understand the human condition, have a feel for people, then that person has a real good chance to make it in this world. And the other thing is common sense. So I think a lawyer needs to have common sense above all, and he needs to have a feel for people. If you can do that, you can imagine how a jury is going to look at the facts of your case 6 months or even 6 years from now, if it takes that long to get through the system, which sometimes it does. And so if you've got that feel for people, if you've got a vision, in other words, so vision, a feel for people, common sense, along with courage and passion.
Well, you certainly have had a reputation of being able to succeed. That your deputy prosecutors have all gone on to really real successful careers. Some people just have governors, presidents, senators, whomever, with their staff. Some are just very gifted at that. And as you were answering my question, you talked about something that is vital to professions and certainly in public policy, and that is, and I don't think it's something you can teach. Some people just have that ability, but talk to us a little more about vision. In the practice of law, when you have all cases to you are important, but some of those cases are far more complex and going to take longer, and your other staff's going to be on it. How do you use the process of vision you're going to have to anticipate some of the moves that will come down the road by the opposition and in the court process. I know it's a very evasive thing, but how do you deal with that?
Well, I always try to look for how others are going to view the case. As I've indicated earlier, the person who has been injured, the client, or the defendant in a criminal case, or the person with a contract dispute, that person is so close to the issue, that person really cannot see the forest for the trees. So he needs or she needs an advocate who's willing to believe in them and who can take their cause and can be aggressive, but can also see down the road. The attorney, to be effective, has got to have vision. He's got to be able to see how others are going to see the case. He's got to be able to see the weaknesses of his own arguments. And he's got to have a feel for people so he can see which arguments are likely to prevail and which are not. He needs to have common sense so that he can see which arguments are frivolous and which arguments are not. Many attorneys would say, well, there's an argument of such and such, or you can argue this. But it really doesn't make any difference that you can argue something. It's how effective it's going to be. Can you do it with passion, and can you do it in a persuasive manner? So all I can say, Tony, in answer to that is that you have to have an insight, and you have to have a morality code that allows you to try every day to do not just something right, but the right thing. And what I guess it goes back to treating people the way you want to be treated, and this comes straight out of the Bible. But you've got to try to live the golden rule. Treat people the way you want to be treated. If you do that with common sense, you're going to be able to see how something looks to others, how it's likely to look a year from now, how a court is liable to look at your argument. If you're able to do those things, you're not just an advocate for your client now. Now you're a person with a moral cause, and it gives you a tremendous advantage over the other side.
Well, isn't that the best way also to serve your client in the first place?
I believe it is.
In relation to that, as you anticipate, in politics sometimes on a campaign staff, there are candidates that they don't maybe say it directly, but really they want their staff to only tell them the good news, never something's going wrong. Well, that candidate's likely to lose because you have to look at the challenges you have too. So in a law firm like yours, when you have other lawyers, do you at times bring in other attorneys to say, maybe you're the lead attorney, but you're close to, and you can have other attorneys say, are you missing certain key points, or are there certain things that you could do different?
Well, and I just have a small firm. I have 5 lawyers in my firm, and but we have regular meetings 2 or 3 times a week where we talk about cases, and I present the cases and to them, or they present them to me. And we try to act in unison if we can. But if it's another attorney presenting a case to me, I'll take oftentimes a role of cross-examiner, and I will cross-examine that lawyer. I will make certain that he is not taking a position that he cannot defend vigorously but effectively. Vigorously doesn't do you any good if it's not going to be effective. So we do that throughout the office, and we always treat it as if the entire firm represents the client, and never speaking with disparate voices. And in addition to that, I have attorneys in North Idaho and other parts of the state, and even in other parts of the country, that I will call from time to time. You mentioned previously, when you mentioned three other lawyers, I've called on each of those people from time to time about cases of mine over the last 20 years. Today I was speaking with a lawyer in Boise, another one in Coeur d'Alene, outside my office about my cases. In addition, that's something that's pretty common among lawyers, to try to reach out, because we always know that we are limited by our own learning. And while that's, as the author of one of the books you mentioned talked about, one of the three essential elements, that is the learning, and one lawyer is oftentimes going to be pretty limited.
And there's a lot of different provisions in criminal law and civil law, and we have a dual system where you're dealing with state courts and federal courts. So, you have practiced in both the state court and federal
Yes.
court, so that adds to the complexity. And so, if you're in an area that you've not been involved in so much, that's when you're more likely to also call on others that have been in that area.
Well, oftentimes, I'll just basically hire another lawyer who's a consultant,
Okay.
and I may pay this person $200 an hour, for example, just to sit with me, sometimes for an hour to go over the case, sometimes to sit with me all day to work on the case. So it's a very common thing.
On that note, Glenn, we have to bring our program to conclusion, but the good news is you've agreed to be back again next week, and we'll continue this discussion called American Law and Ethics. And it's been intriguing to me. It's been very informative, and I'm sure that our viewers throughout here in the Northwest and even in Canada have appreciated your expertise and your thoughts and your generosity to share those. Thank you so much.
You're welcome.
Ladies and gentlemen, as I said, Glenn Walker will be back for his fourth program as we're dealing with law. And this week and next week, we are specifically dealing with the subtopic American Law and Ethics, and we shall discuss that and finish that next week. I hope you'll be with us at that time. Until then, please have a good week. I am Tony Stewart.
Recorded on the campus of North Idaho College, Public Forum is the longest-running entirely college-produced program on PBS. Each episode is pre-recorded live and is an educational outreach from North Idaho College. Please join us again at this same time next week for another edition of Public Forum on this public television station. Welcome to Public Forum, a community outreach program produced by North Idaho College located on Lake Coeur d'Alene. Featuring guests from around the globe addressing a wide variety of subjects, Public Forum serves to educate and enlighten. Please join host and moderator, political scientist Tony Stewart, in welcoming today's guest.
I am most pleased to welcome back our guests from the past 3 weeks. This is the fourth week of our 4-week series dealing with American jurisprudence and law. And last week we talked about American law and ethics, and that is the topic again this week. I welcome back to the program Glenn Walker. My friend Glenn Walker is a very successful attorney. He has a law firm here in Coeur d'Alene, Idaho, practicing in both civil and criminal law. But prior to that, he also served with great distinction as the prosecuting attorney for a decade. And during that time, not only was he successful in prosecution of his cases, but also he was instrumental in the development of law in this state that deal with particularly hate crimes. and he also got the first conviction in our state of a hate crime. Glenn, welcome back. It's always a pleasure to see you and to have you on our program.
Thank you.
I recall back some years ago when we had a fascinating program with you and a representative from Amnesty International dealing with the death penalty. So you've been with us on different occasions on different subjects. Last week we covered a lot of issues concerning ethical standards and ethical positions by attorneys and their clients and an officer of the court. I want to delve into constitutional questions in relation to how lawyers perform in dealing with what we call substantive due process, the content of law. And court procedural questions arise too under the Bill of Rights and the 14th Amendment. But I want to start with a quote from, again, one of the books I talked about last week, The Moral Compass of the American Lawyer, by Mr. Richard Zintren and Carol Langford. And there is in Chapter 1 a statement that says this: protecting the rights of individuals is the best way to protect society. Would you play on that statement? And, I'll preface it by saying that something that troubles me sometimes is that someone will say, well, I don't know why we're concerned about all of these procedures or motions in court or even appeals on constitutional questions, because if you're not guilty, you have no problem. You have no concern. And so I think this quote is getting at correcting that often what we think is misjudgment.
Well, one that comes to my mind that might be easy, a couple of ones that might be easy, is that we know that we haven't done anything wrong. I know that I haven't done anything wrong. I know that my family hasn't, but I can't guarantee that some member of my family I can't guarantee they won't be falsely accused. Mm-hmm. So suppose they are falsely accused, then obviously they're going to have representation, and we're going to have to go in and try to protect their rights, because again, we're just assuming that they're falsely accused. A person, you can't just assume that justice will be done. I mean, how many times do you get people together and have somebody in the group disagree with somebody else? So we're not going to always agree, and so justice isn't always going to be done. A person can be falsely accused, and I'm not saying that there's going to be a conspiracy, but there's going to be false identifications, and there's going to be a misjudgment of a person's intent. So oftentimes, it's not whether an act was done, it's whether the act was done with criminal intent. And so that issue of criminal intent is so very important. So you've got to protect a person's individual rights, or we as a group have no rights at all. The other issue that I was going to, I lost my train of thought there for just a second, Tony, so why don't you go ahead.
Surely. We can support your position by saying that with this modern technology, DNA has just been an incredible breakthrough, not only to assist in convicting guilty people, but also to try to not send innocent people to prison. And there was a meeting some time ago in Chicago where I think there was 20-some people who had been sentenced to life in prison or death that had been released because DNA proved they were actually not the person. Again, it was someone misidentifying. That is, some people look alike to some extent, and so a witness had identified him, and this was an error. So certainly there is that kind of problem. But I want to move on to discuss, if I may, something about civil law under the Constitution, that remarkable amendment, the First Amendment, civil liberties. So many lawyers are involved in civil liberties cases. I'm speaking particularly of free speech and free press. And of course, the court over time has applied that to the 14th Amendment, so we can talk about local government, national government, or even in the private sector. Would you share with our viewers why we're not dealing with a criminal case now, but dealing with someone feeling that they have been denied the right to speak or to print or the right to have a rally or to march? Give us your take on, again, from this ethical viewpoint, why it's so important that in democracy that we don't confine speech and gatherings and assemblies only to those that the majority of us agree with.
Well, I guess you wouldn't have a democracy of any kind. You wouldn't have any freedom if you didn't have that freedom of speech. You and I might agree on a subject, and that's fine. But the odds are there's going to be something that we disagree about. That's the way it's going to be with any two people, with any 3 people, or 30 people, or 300,000, or 300 million. So you simply have to have. I think that one. I think that one's pretty fundamental to any notion of liberty, and I think almost all Americans recognize that while it might be unpleasant for us at times, but we simply have to do it.
I'm here, and I'm not an apologist. I'm here to defend the role of attorneys in our society, and I, as a political scientist myself, not an attorney but a political scientist, I think that I have some appreciation of court cases and how they evolve. And I want to get you to respond to this statement also, is that if we had no attorneys and we had no one to go to court when someone felt that they had been denied the use of the First Amendment, which includes free speech and free press and the right to peacefully assemble, to petition your government for grievances, and also the right to religious freedom and no establishment. And the courts over time have said also the right of association. And if we go on down to the Ninth Amendment and the Fourth and others, we also find something else called privacy. If there were no attorneys to take a case for a client, and by the way, some attorneys take cases in which the client has been denied one of those rights is very poor, and there'd be no relief in court without an attorney taking the case with actually no cost to the client, or organizations like the NAACP and others, American Civil Liberties Union, whatever group it might be. Would you just share with us what kind of society would we live in if there was never an advocate for that person in court? Because those individuals oftentimes are not, they know what their wish is, they don't have the background to defend it from a constitutional law viewpoint.
Well, of course, it's easy to pick on attorneys, and attorneys' jokes are popular in every level of society. I know that. But the answer to your question would be it would obviously be anarchy. And if we didn't have attorneys, what we would do is we would create them. If we didn't have attorneys, we would create people who perform the role that attorneys now use. The attorneys, as you indicated earlier in the previous show, one of the 3 things about attorneys that are crucial is that they have to have the learning and the availability, the access. People need someone to speak for them, to advocate for them, to protect their rights, to represent them. And if you didn't have attorneys, then we would, if we were an anarchic society, then we would simply try to get rid of this chaos. We would try to bring harmony to our chaos, and so we would ask people to step up and speak for us and do these things. We would try to end the chaos, we would try to bring harmony, and we would create people to do what attorneys now do. But we wouldn't have any learning for them. So the attorneys are simply people who are learned in the law, learned in how to bring harmony out of chaos. So if we didn't have them, we'd create them.
And when you deal with these issues like civil liberties and another area, civil rights, you've been trained, and other lawyers, in law school and practice and workshops and law journals and all. The average person oftentimes doesn't understand the difference between substantive due process and procedural due process, or procedural dealing with how people are treated when they're arrested, or how juries are selected, or do you have a right to counsel? And the substantive dealing with the actual content of the law, is it reasonable and fair? And so that's more of an editorial comment of saying, you don't get that by majoring in electrical engineering or even highly educated people. It's a particular training of the law.
No, and you don't really get it in 3 years of law school.
Right.
You get the beginning. It's the foot in the door, so to speak. And at that point in time, you start to learn, and you get into court, and you learn your way around. And years later, you have the ability to handle the complex case.
Let's talk a little bit about the area of civil rights. And you again, I know you so well, and you have a very good reputation of supporting people's rights to be free from discrimination. With such famous cases, the Brown versus Board of Education, 1954, and Loving versus Virginia, dealing with the Brown case, of course, having bring an end to so-called legal segregation, and Loving versus Virginia, dealing with anti-miscegenation laws, so you can interracially marry, people can. All those are just good examples. And in every one of those cases, there was an organization and an attorney or a group of attorneys that battled for a long time through many courts to reverse the law. In this country, even the U.S. Supreme Court had said in 1896 that separate but equal facilities were okay. 58 years later, the court discovered they were wrong. So I guess my question is, in dealing with civil rights in particular, when courts have allowed, or legislative bodies have allowed laws that treat people differently, as Dr. King said, a person told me the other day, said, Tony, if you look at it carefully, usually those changes don't come from inside elected government officials. It comes from outside through like lawyers pursuing those issues or marches and so forth. So would you just share with us your view on how important it is to challenge certain laws? You and I both are Southerners, but came from the South where a lot of those local ordinances were.
Well, I grew up in the segregated South, and I grew up with typical biases of a Southern white male, and I found that just a few years later, I was teaching school in small town Lake Wales, Florida. The black I was hired to teach history, but the black and the white schools were merged about 2-3 weeks before school was supposed to start. And all of a sudden now I'm teaching, instead of in an almost all white school, I'm teaching in a school that's about 1/3 black and 2/3 white. Most of my students were black. And I had to realize really quickly, while I grew up in the segregated South, I was no longer in the segregated South. And it's easy to dislike someone if you don't have any knowledge of anything, basically. It's easy to dislike lawyers. It's easy to dislike blacks. It's easy to dislike Mexican Americans. But when you realize that these are people just like you, and now you have to decide morally inside: are you going to treat somebody poorly? And a person with a good moral compass won't be able to do that. That was thrust upon us as Southerners, and it came through the efforts of advocates. It wasn't only lawyers, but without active people willing to volunteer their time, it wouldn't have happened. So I guess in answer to your question, I appreciate the history of that. I was essentially at that point in time in my life, I was on the other side of it because I didn't want those changes to occur, nor had I thought about them for the most part. I was a young person who hadn't dealt with them, but I go back to the South a great deal today, and I see what a wonderful, vibrant part of our country it is, and it was not that way prior to integration. So I'm very grateful that it happened, and every time I look at our education system today, I'm very thankful for the fact that we had the activists in those days, although it wasn't something that I probably personally wanted.
We call great individuals like that ethical activists. They challenge the customs and they challenge what Dr. King called unfair laws. In introducing you each week, I made the point that when you were prosecutor, you worked very hard dealing with, in this state of Idaho, laws dealing with hate crimes. One of those was the malicious harassment law. First had a criminal provision, later there was a civil remedies provision added. You and your staff were very involved with the Domestic Terrorist Control Act and all of those. What I want to get at is that in many of the states when those laws passed, it said that if someone assaults someone, there's already laws on the books against assault, but if one can prove that the person was assaulted because they were a person of color or Jewish or belonged to some community of people that resulted in that person becoming a target, that you can have what we call enhancement punishment. You can say the person might get 5 years for the assault and may get 2 years because they committed a hate crime in addition to that. And the U.S. Supreme Court in the Mitchell case some years ago said that is constitutional. So would you refer to that as a way of combating crime and also trying to protect those who are most likely to become victims? By the way, what's interesting about the Mitchell case was a group of young African Americans had watched the movie Mississippi Burning, and they went out and attacked a young white man during their anger, and he was attacked because he was white. So it doesn't matter who it is, whether it's a person of color or not. When someone is victimized because of who they are, then the law takes effect.
Well, we have to recognize that prior to these laws being passed, the malicious harassment law that you talked about, we just had in Idaho, we just had typically our misdemeanor assault law. Until we put the enhanced penalty, until we made it a felony, these kinds of crimes weren't being treated significantly or seriously, the new enhanced penalty made it so that law enforcement would recognize it as a policy matter of great significance. We used the law to essentially start to change people's attitudes, and the law made Idaho, in my opinion, a better place to be. It let everybody know that this is not a haven for discrimination. It never has been, and it wasn't. None of us who lived here meant it to be, and we basically took our state back. The malicious harassment law helped us do that, and I think it has helped in other states. So the enhanced penalty, basically, it was a matter of recognizing that to assault somebody is a bad thing. To be on the end of the receiving end of the assault is a bad thing, and nobody is going to like that. But if it attacks something that you can't do anything about, your ethnicity or your color, if it's designed to treat you as less than human, there's nothing at all wrong with a law recognizing that where a person is attacked for those reasons and his quality of life is affected greater because of his color or ethnicity, then there's nothing at all unconstitutional about recognizing that fact and putting a higher penalty on it.
Again, we're talking about ethics and law, and isn't it a real ethical issue and a moral issue to say that if someone, wherever in the United States, is subject to be more likely to be a victim because of their race or their ethnic background and those kind of things, that by having such a law, you're not only protecting the particular person who becomes a victim, which is very essential, but you're increasing the protection of that whole community because of the message of hate or some hate group, such as the KKK. It's a law and order issue too, and an ethical question, is it not?
It is, and I can't say it any better than that.
Let me just take this one step further, because I want you to have credit. I just believe when people do the right thing that they should really be recognized for it. Once that law is passed, it's been on books a while, you got the first conviction. I think it was a plea bargain, which is significant. But without that law, what would you have done? What could you have done?
Well, in that particular case, we wouldn't have been able to do anything. The particular issue was simply a misdemeanor. A person might have gotten a day in jail, or he might not have. It would have had no consequence whatsoever.
In that particular case, there was a man that was attacked at I believe at one of the
grocery store
because he was African American, I believe.
Yes.
And so, but that sent a loud message, did it not?
I believe it did. It was the beginning, and we've had some effective jury trials since that time. Because that was the beginning. It was about 1987.
Mm-hmm. Now I want to deal with you again, and you have a client, and it's a rather complicated case, and you've really done your homework, as you always do, and you're preparing strategy for representing your client. Again, as we've talked about, the ethics of an attorney is to give full and energetic and passionate representation of their client. And you're going before a particular judge, and you've got another case you're going through with another judge. Judges have philosophies like everyone else, and legitimate philosophies from how they interpret the Constitution and procedural issues and all. How do you take into consideration your presentation? Because even though there's a jury there, and we'll talk about that in a minute, but the jury to decide what is allowed or not allowed in the court, the rulings of the judge has a real major impact on the trial and the jury. What do you take into consideration, having some knowledge of the philosophy of the judge?
Well, if I've got half a dozen different judges that my various cases are in front of, I know that I've got a half a dozen different approaches I'm going to have to take. If I'm going to talk to the PTA at an elementary school, I'm going to make a different approach depending upon who are the members of the PTA. If I'm going to the school board, I'm going to make an approach dependent upon who are the members and how they look at things. So it's just a matter of learning the judges through the years, learning the judges' approach and their reputation. They have an obligation to follow the law, but they are going to have a different approach to how they run that courtroom. And many will treat it as if this is my courtroom, I run it, I control everything, almost essentially like a dictator, and they would think of it as a benevolent dictator probably, and I might not. But every judge is different, and you just simply have to know the personalities and know how they're going to react. But basically, you've got to treat that judge with dignity and treat that judge with respect. You are an officer of the court, while you are walking a tightrope between your client's interest and the judge and the jury, if you've got a jury, as well as some responsibility of fair dealing with the opposing side.
Again, that's that ethical question we brought up last week, and that is this balancing act. You've got to represent your client, and that's so essential. But you've also got to. You can only go so far with a judge that has a certain specific procedure in the courtroom, and you've got to be concerned about the jury. Sometimes do you show a kind of energy and passion that's more than you normally would because you have a client that's, should I say, more demanding than another client?
Well, indeed you do. I was in court today, and I found myself a little bit posturing to the judge because I knew my client demanded it of me. And quite frankly, she had a right to demand it of me because she had been hurt a great deal, and she needed to know that I was zealously there for her. And I needed to let the judge know that. It was an issue that probably the attitude that I took wasn't going to make a huge amount of difference to him, but it might have. And I had to posture a little bit, and we all have to do that from time to time.
And the research is done. Chief Justice William Rehnquist with the U.S. Supreme Court, in a case called the Walters case, once said something to that effect. I believe back in 1985, when he said concerning attorneys that they must advance their clients' cause by any ethical means, and that again, that is ethical, but you're being a strong advocate as it will allow under the circumstance. Let's go to the jury for a moment. We've mentioned a little bit in previous cases, but again, the same thing. You're at a more disadvantage with the jury because they're new each time. You learn the procedures of a judge. How are some of the ways that you can attempt to read the jury as you're trying the best to represent your client?
Well, it starts off in the jury selection. When you in one of our previous shows, we talked about trying to find that perfect juror, that fair jury. And what we're really trying to do is we're trying to find the jury who is least likely to be prejudiced against us. So we're trying to get rid of the people that are against us. So we start off in the jury selection trying to essentially try our case to the jury, and the judges don't want us to do that, but we have to. We try to expose our facts and our issues to the jury at that point, and try to get people who are as unbiased as possible at that point. We are always working. We have to make sure that the jury is alert, paying attention. If we have to, in jury selection, try to weed out leaders, people who would be leaders against us, try to find people who would be leaders for us, because you've got to have, in a civil case, you've got to have 3/4 of the people, or 9 out of 12, vote your way. In a criminal case, you've got to have all 12.
And there's people that emerge as leaders on the jury, don't they?
Oh, no question about it. And they come, you're oftentimes surprised which ones end up being the leaders. I haven't lost very many cases in my career, but I have lost a few. And I remember the first case that I lost as a prosecutor. It was a DUI trial, and I had an officer sitting beside me. And in those days, I used to, kind of play a game of picking, privately, informally, of course, who was going to be the foreman. And the person I picked as being my foreman for my win ended up being the foreman, all right, but I didn't win. And so you just It's an imperfect science.
Your foreman turned out to be on the other side, sounds
He did.
like.
He was the foreman, but he was not. He was not for me.
It's not a perfect science, is it?
No, it isn't.
We're about out of time, but as you're presenting your case and you're looking at the jury, and I know that you have to concern yourself with the judge, but you're really focusing on the jury. How do you do that? Do you focus on one at a time, or do you? I had a friend who was a lawyer, and he was just brilliant. He hardly ever lost a case in North Carolina, and he always stayed physically close to the jury. He often talked or had, eye contact with one juror at a time.
Well, I try to have eye contact. I always make sure I try to have eye contact, and I don't focus on one person. I move it around. I try to make sure if I've got a 12-person jury instead of a 6-person jury, that I make eye contact with every single person on the jury as much as possible. But you can't just sit there during the middle of the trial and do that. There's the 3 times you can do it in the jury selection and in the opening statement and the closing argument. The rest of the time, you have to focus on your witnesses.
I'm sorry we're out of time. It is so much fun doing these programs with you, but thank you, Glenn Walker, so much for being with us for these 4 programs on jurisprudence and the law, and particularly the last 2 weeks we've emphasized the law and ethics, and hope you'll come back in the future again and be on some programs with us on some of the subjects we do. It's always a pleasure to have you here.
Thank you.
Ladies and gentlemen, it's been our pleasure to bring you this 4-week series on jurisprudence and law and American law, and I hope you'll be with us again next week at this same time. We'll move to yet another issue. Until then, please have a good week. I am Tony Stewart.
Recorded on the campus of North Idaho College, Public Forum is the longest-running entirely college-produced program on PBS. Each episode is pre-recorded live and is an educational outreach from North Idaho College. Please join us again at this same time next week for another edition of Public Forum on this public television station.